In this episode, we will be discussing California landlord may not evict victims of domestic violence. The California Code of Civil Procedure, Chapter 4, Section 1161.3, prohibits landlords from taking the following actions against tenants who are victims of domestic violence and other crimes. May not terminate or fail to renew. A landlord shall not terminate a tenancy or fail to renew a tenancy based upon an act against a tenant or a tenant's household member that constitutes domestic violence, sexual assault, stalking, human trafficking, or abuse of an elder or a dependent adult, if both of the following apply. First, the act has been documented by one of the following: a temporary restraining order, emergency protective order, or protective order lawfully issued within the last 180 days that protects the tenant or household member. A copy of a written report within the last 180 days by a peace officer employed by a state or local law enforcement agency stating that the tenant or household member has filed a report alleging that he or she is a victim of domestic violence, sexual assault, stalking, human trafficking, or abuse of an elder or a dependent adult. Documentation from a qualified third party acting in his or her professional capacity to indicate that the tenant or household member is seeking assistance for physical or mental injuries or abuse resulting from an act of domestic violence, sexual assault, stalking, human trafficking, elder abuse, or dependent adult abuse. The documentation may be signed by a person who meets the requirements for a sexual assault counselor, domestic violence counselor, or a human trafficking caseworker only if the documentation displays the letterhead of the office, hospital, institution, center, or organization as appropriate that engages or employs, whether financially compensated or not, this counselor or caseworker. And second, the person against whom the protective order has been issued, or who was named in the police report or any other permissible documentation, is not a tenant at the same dwelling unit as the victim. Lawful reasons to terminate victims. A landlord may terminate or decline to renew a tenancy after the tenant has availed himself or herself of the protections afforded by these laws if both of the following apply. First, either of the following must be true. The tenant allows the person against whom the protective order has been issued, or who is named in other permissible documentation, to visit the property. The landlord reasonably believes that the presence of the person against whom the protection order has been issued poses a physical threat to other tenants, guests, or licensees, or to a tenant's right to quiet possession. Second, and the landlord previously gave at least 3 days' notice to the tenant to correct either of the violations. It is important to note, notwithstanding any provision in the lease to the contrary, the landlord shall not be liable to any other tenants for any action that arises due to the landlord's compliance with this section. Tenant-victim privacy. A landlord shall not disclose any information provided by a tenant under this section to a third party unless either of the following are true. The tenant has consented in writing to the disclosure, or the disclosure is required by law or court order. It is important to note a landlord's communication with the qualified third party who provides documentation in order to verify the contents of that documentation is not a disclosure for the purposes of this section. For additional laws and articles, visit AmericanLandlord.com.